because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement, that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28 after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as number one, he's saying, okay, there's no caveat, there's no, oh, hey, we need this. Okay. So number two, obviously Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL since blank.
Right.
So he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is, we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of, to commit crimes, period. And then it makes it a gang violation to commit crimes in furtherance.
And that's why number one is
right. And so, number one is whatever number one is, but that number two says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm going to defer whatever the court's ruling is, but it's that he's offering additional information. He's comfortable enough to say.
I think that is okay, I think it was about 3 years beforehand, so it must have been about 2012.
Okay,
so three.
Number three.
Didn't we read that into the record?
We did. We read the response Mr. Wright gave.
Okay.
And I believe we read.
We did read into the record.
If I make it, I believe we read as well the portion of 452 that was number three, and then the final. I think we read number threes into the record, just so that the court is hearing what I believe is the full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
We read at least the final version of number 3.
We
many,
did.
many, many times.
Okay.
So number 4. Back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number 4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination, now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor,
Number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4,